What are the letters in probate? It's a question we get a lot, and it's a very super important document. So we're going to get into that right now. Welcome back to the channel. I'm Brendan Mohr, California Realtor and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed professional California fiduciary. I'm also a licensed California real estate broker, a licensed Nevada realtor, and I'm a bonded and registered legal document assistant in both California and Nevada.
Now, please like our video right now, subscribe to our channel. Want your probate done for little to no cost? Well, every day we help people save thousands of dollars and eliminate headaches with our one-of-a-kind probate administration service and real estate listing combo. So please reach out to us about that, or reach out to us with any questions about probate real estate. Comment on this video. Our contact information is below, so please email, text us, call us, because we can help you. So Bill, what are the letters in a probate sale?
Sure, the letters, as you said before, it can be very confusing to people unfamiliar with probate, but basically all the letters is they are a one-page document that the court issues to whoever the administrator or the executor is. And that one document gives that administrator or executor the legal authority to act for the estate. And that's all they are, kind of like a badge showing that this person is legally authorized to make decisions and take care of the estate.
And it's really very crucial in really getting the process going, right?
Absolutely.
Now let's talk about, there's a few different types. And in another video, we'll talk about what each type really means and if there's anything that really can change because different types of letters. But one is letters testamentary. Let's see, we have letters of administration.
Right.
It's probably the one I see most common.
Yeah, you really see that one probably more often than not.
Now, one that we've seen recently, and maybe for a subject of a different video, because you were the special administrator on one, special administration.
Right, letters of special administration. And like that says, there's special circumstances when you get those.
And I suppose the last one, letters of administration with will annexed. But again, letters of administration are the most common one, I think.
Correct.
We see.
Yeah. And no matter what type of letters you get, they're normally always just one single page document from the court.
Now, who prepares the letters?
Well, a lot of people think that the court prepares them, but that's actually not true. The person who prepares them is either going to be, if you have a probate attorney, it'll either be the probate attorney, or if you're using a service like ours, we'll prepare them for the court. And
that's something up until not too long ago, I thought it was actually the court that filled everything out on those until I saw one. I saw one with a mistake on it, and I had to send it back to the attorney. I'll get to that story a little bit later. But what's the first step in obtaining the letters?
Well, the very first step in obtaining the letters is you have to file to start the probate. So you have to prepare and file the petition for probate. And at the time you file that petition for probate, the court will assign you that initial first hearing date. And between the time you file that petition for probate and that first hearing date, you got to get everything in order and prepared so that when that hearing date rolls around, the court can okay everything and issue those all important letters.
And then of course, that's very important to everything the administrator or executor does at that point, gives them the authority. Now, its role in real estate is pretty significant.
Absolutely. You're not going to be able to close a probate sale without those letters. Title companies simply won't do it. So you got to have them. They're all important. They're all important.
And really, you can't even sign a listing agreement until the letters have come out. And one of the key things that the letters do is it gives us certain type of authority, which we've talked about it in a lot of our videos, which is full authority and limited authority. One time I was helping a client, and it was an attorney who was handling the estate. Sometimes Bill is handling the probate, and in this case, I was given the letters. I was told in advance that they had full authority, but I see the letters and they're just two different boxes. It says whether they have full authority or limited authority. And I'd always made the assumption that it is actually the judge who marks each one. What I didn't know was that it's actually the attorney or the paralegal, whoever submitted that to the court, who pre-checks that box based on the circumstances of the probate. And the box was empty. So that's going to be a big problem, right? What happens, you know?
Yeah.
I send that over to the title company in the end, and what do they do?
Well, you could, that's a big time problem, because if the right box is not checked on those letters, you could end up getting all the way up to your date of closing, and the title company's legal department is reviewing all the probate docs, and they come across the letters that doesn't have the box checked, and they're going to say, sorry, we're not closing escrow, this is incorrect. So you really need a good real estate agent who knows probate, like Brendan does, to catch things like that early, so that you don't get all the way to the end of where you're supposed to close escrow and you can't. So
yeah, because in this case, the attorney was definitely a capable, and this attorney, and I'm not knocking the attorneys at all, but sometimes there's so many different documents and boxes to check and things to fill out, different lines to fill out. It really does take lots of different eyes on it.
Yeah.
So in this case, the paralegal emailed me the letters, and these letters had been in existence for over a year, and nobody ever noticed that the box was not checked for the type of authority until it came to me. And then I sent it back to them. I said, hey, it looks like the court missed the box here. Mm-hmm. I didn't realize that it wasn't the court. It was probably that paralegal I was sending it back to. And she was probably a little bit embarrassed about that, but you know what, it happens. And that's why you have to have lots of different trained eyes looking at this stuff. Yeah. So it's just,
everybody's human, we make mistakes, miss a box or something, but like Brendan says, it's good to have more than one set of trained eyes on it, so you catch it early and can get it corrected.
Because ultimately what happens is we need to know what type of authority they have. That changes how the sale really runs. And please watch our video, Full Authority versus Limited Authority. It's linked in our About section. It's further down our channel, one of the first videos we ever did. It's super important, right?
Very helpful.
Yeah, I mean, the difference between full and limited authority in a probate sale is gigantic. And that's what the letters will tell you. But at the end of the sale, the title company has to have a certified copy.
Right, court certified. That's correct.
Yes.
It has to be correct.
Yes, and has to be correct. And not just one that you can download from the website. It has to be the court certified copy, which has to be ordered in advance. Yeah. So,
and there is just a side note on that. There is a cost to that. Currently, to get a certified copy of the letters, courts will charge you $40.50. So if you're ever in a position where you got to go get one, make sure you have a check or credit card or cash to pay for that.
And it's something definitely. We get a lot of real estate agents, realtors who are watching our channel. It's something that if you don't have a copy of that to start with, make sure that please request it from, say, whoever is probating the estate, whichever probate professional, maybe that's an attorney or not, that they have a copy. Ask to see it, and maybe just send it over to the title company, because the title company will also review it too and see if it's good for them.
Yeah, that's a very good point.
And then you have three eyes on it, and then because you do not want to get to time to close escrow and the document be wrong.
Right. That's like a major problem if you get into that situation.
So I suppose that's about all we have on this. We'll get into it in a later video. So please look into that later on, or maybe we've already had the video drop when you found this video about different types of letters and what their role is for the different letters, testamentary or administration.
Sure.
Thank you so much for watching. Now, what you really need is to know how to hire a great real estate agent for a probate sale. That way you can help eliminate any of the problems that you might have with the letters. So linked next is a video we call How to Hire a Probate Realtor, and it has 10 interview questions for hiring a probate realtor and an additional 15 questions on a downloadable list of those questions. And it's going to appear right above Phil's head just about now.